Good evening, everybody. Welcome to the Käte Hamburger Center for Advanced Study, Law as Culture. This is for the new fellows. On the one side, Professor Gotzo, Professor Gosewinkel, and Professor Melich from Moscow, Berlin, and Brazil, Sao Paulo. Welcome to our center. Welcome also to the North American people from the North American program from Bonn, and Professor Schneck from the University of Osnabrück. Very welcome to our center. The talk of Sabine Meyer, I will present her later on a little bit, does take place in the intersection of different disciplines, and perhaps you will allow me to remind some of them. It is in between American studies on the one side, literary criticism, legal history, law and literature, and so forth. So the American studies context, Sabine Meyer, she is an Americanist, and what is perhaps also interesting for some of you, both of us have something in common. We were part of the occasional community that was built after September 11 in the United States. She was in Minnesota as a DAAD student with a stipend. I, a little bit older than she, not very much, was endowed with a Fulbright Distinguished Chair of German Studies at Washington University in St. Louis, and both of us, we had the opportunity to exchange about it, were part of this growing and emerging occasional community after September 11, and this was absolutely fascinating. We have to do one day a look back, and I remember very well the series that Professor Zielke had prepared and opened up into two, I think, or one even, yes. So then I couldn't participate because I had been there at that very moment in the States. So why, that is a question, why America is so important for the social sciences. Why do we still follow up Tocqueville, Max Weber, Baudrillard? Where does it come from that America seems to be a paradigmatic case where so many people come to new insights, and perhaps also about law and about literature? The second discipline that we touch beyond American studies is literature. So literature as such, we are in a legal theory context, legal sociology, in a context of the humanities in general. What about literature? So the end of naive readings of literature has very often been announced. On the other side, we are in between looking at reception processes, productive or aesthetics that are focused on the production side, but who is really still reading literature, and who is doing something that formerly was called werkimmanente Analyse. What an horror. On the other way, on the other end of the scale, perhaps sometimes reading of that sort might be still interesting. We'll be very interested to know and to learn what's your way of reading texts. Finally, literature and the law, another big topic, even a discipline in the United States of America at least, and in the common law tradition, countries and legal cultures, highly debated, very much also linked with the question, what is the importance of storytelling, whether the story, the telling, the narrative is the link between the law and literature, because you never can be a good lawyer if you're not able to tell a good story, for example. But however, perhaps some legal cultures are closer to the narrative and narrative cultures than others, and what's the role in that for indigenous rights questions. And finally, the very difficult question, what kind of normativity springs off the words out of literature? And this is also a topic of your talk. It's a very general question, but on the other side we have to give answers on a much more concrete level. Legal history, another field that comes into the debate, and fraudulent treaties that you will talk about when there is no knowledge of American legal history in this respect. I think the debate would be absolutely impossible. So for all this, Sabine Meyer is particularly well prepared, as her CV shows. I think most of you have read the CV, and thereby you will know that she was the coordinator of the Osnabrück Summer Institute on the cultural study of the law. It sounds a little bit familiar to our ears here at the center. And as I learned by Professor Schneck, it was even the very moment when both of the centers and perspectives and projects were developed that there had been an indirect, at least, interaction. And as we know, very successfully, because one of the last projects you were writing for the DFG, if I see it together, was so successful that in the future, the tradition of property law in the United States of America will have a much closer reading and a much better understanding. So this seems to be the general topic. I could continue in a very fascinating CV, much too fascinating for such a young lady, but let me stick to just one important result of her research that came out of her dissertation, and this has been a book. We would have liked to make a book launch about it, and you may take it at least as a small substitute to it, because the book has had a great success. Not only for the title, but the title is wonderful in itself. We are what we drink. Most alcoholics in this room would agree with this interpretation, but some who are less in such a situation might also say and have an idea how much we are impregnated by what we eat and what we drink. So this might be a first allusion to the Durkheim Salon, where we will meet later on, and to have a glass of wine, a glass of red wine, of white wine, and some also those horrible American drinks. I won't pronounce the name, but some of you might know the zero stuff. Okay, so I think I shouldn't be too long. I would like to welcome you once again, because also for something that is rather important. The floor is yours because also we are very grateful to you that we could profit so much from your premature maturity, I would say, if this is allowed, as a serious worker in the multidisciplinary field of the humanities, for whom the law is one source of critique, inspiration, information about the dynamics of different civilizations. So welcome to your talk. The floor is yours.
Good evening. Thank you, Werner, for this tremendously kind and personal introduction. Before I start my talk, I would like to say that the past 8 months here at the Käte Hamburger Center have been a wonderful time for me. And I always tell my students to brainstorm to come up with spontaneous ideas and insights. And if I brainstorm, Käte Hamburger Kolleg Recht als Kultur, terms such as intellectual exchange, intellectual inspiration, architectural beauty, but also conviviality and human warmth come to mind. And I would like to take the opportunity to thank all of you, the staff, Werner and Nina, all of the staff of the Käte Hamburger Kolleg, and also my fellows, the past cohort, represented tonight by Thomas, and the present cohort, and it's been truly wonderful for me here. Thank you. The talk today I called Indigenous Literature Meets Human Rights, Indigenous Rights Discourse in the Native American Historical Novel. Before I start talking about the topic at hand, I want to talk briefly about my project from which this topic springs. It's actually the book I've been writing throughout my stay here at Bonn, and of course also before, which is provisionally titled Visions of Peoplehood and Indigenous Futurity in Native American Removal Literature. And in this book, I set out to explore visions of peoplehood in non-fictional and fictional texts by Native American writers from the 1830s onwards to the present day. The texts I've chosen all have in common that they deal with the so-called Indian removal. And for the non-Americanists amongst you, the Indian removal was the forced relocation of the southeastern native tribes to what today is Oklahoma in the late 1830s. And the most emblematic and traumatic moment of this removal was actually the Trail of Tears, and this was the forced relocation of the Cherokee tribe in the fall and winter of 1838 and 1839, and a fourth of all those removed passed away and died on the route to Oklahoma. So it's a very traumatic moment inscribed into trans-indigenous memory, so to speak. Why removal literature when I'm talking obviously about the law, as Werner said? Well, in the removal period, Anglo-American law shaped Native American lives to a heretofore unprecedented degree. Removal brought forth a wave of legal documents, and I just want to mention the Marshall Trilogy. This was the Supreme Court decision, the three rulings actually issued by the Marshall Court, the Supreme Court headed by John Marshall, and they're called Johnson versus McIntosh, Cherokee Nation versus Georgia, and Worcester versus Georgia. And these three decisions, decided in the 1820s and 1830s, have shaped Native American lives until the present day, because probably many of you know there's the process of stare decisis in American law, so you always have to rely on prior decisions. So this is why the decisions, the three rulings, are still relevant today. And they are at the heart of what is called federal Indian law. In my project, I explore the aesthetic mediation and construction of Native peoplehood by a conjoined reading of Native removal literature and US American, as well as international legal texts from the time of removal up to the present day. I analyze how these texts negotiate, both thematically and formally, the legal debates about sovereignty, property, and land ownership that were at the heart of the removal controversy. I also investigate from which legal and political context these texts sprang, and how these contexts appropriate and interact with the narrative's historical legal political context. My analyses seek to demonstrate that through their literary recourse to the law, these Native writers attempt to claim a form of a collective sovereignty from within existing power structures. So this is sort of the general outlook of my project. What I will present today is actually the third chapter of the book. In the preceding chapters, I explore Native removal writings from the 1830s to the 1930s, reading them in conjunction with the Marshall Trilogy and the American policy of assimilation and allotment, which is a land policy splitting up Native American communal land holdings into parcels of privately owned parcels of land. My third chapter focuses on contemporary removal literature from the 1990s, which I will read in conversation with the debates on indigenous rights that took place in the United Nations around the same time. Cherokee writer Robert Conley's Mountain Wind Song, a novel of the Trail of Tears from 1992, is a critique of the idea that Native American rights can be secured from within the United States legal order. Through the jarring juxtaposition of historical legal documents and a romantic plot, the novel deconstructs the idea of domestic law as an agent of change and introduces the language of human rights as an alternative framework. Cherokee writer Diane Clancy's Pushing the Bear, a novel of the Trail of Tears, 1996, engages with a question that figured prominently in the debates about indigenous rights, namely whether these rights can be realized within the context of a human rights regime that puts the individual center stage. On closer scrutiny, the novel opens up an alternative way of thinking about the relationship between individual and group rights. It thereby contributes to closing the theoretical gap between individual and group rights, which stymied the debates about indigenous rights considerably. So this is sort of the plan for today. And the first part of my talk I call The Death of Federal Indian Law, Robert Conley's Mountain Wind Song, and the Limits of Domestic Law. In his 1941 Handbook of Federal Indian Law, Felix S. Cohen, who is credited with having created the field of federal Indian law, outlines what he considers the three fundamental principles generally adhered to by courts when ruling on the nature of native tribal powers ever since the Marshall decisions in the 1820s and 30s. And here I quote the text. First, the first is missing. An Indian tribe possesses in the first instance all the powers of any sovereign state. Second, conquest renders the tribe subject to the legislative power of the United States, and in substance terminates the external powers of sovereignty of the tribe. For example, its power to enter into treaties with foreign nations, but does not by itself affect the internal sovereignty of the tribe, that is, its powers of local self-government. Third, these powers are subject to qualification by treaties and by express legislation of Congress, but, save as thus expressly qualified, full powers of internal sovereignty are vested in the Indian tribes and in their duly constituted organs of government. End of quote. One might add here the fact that ever since Johnson versus McIntosh, the first ruling in the Marshall Trilogy, Native Americans have been considered the occupants and not the owners of the land. In addition, they can only sell those lands to the United States government and not to anyone else. Aside from individual Supreme Court rulings limiting the rights of natives, this Marshallian framework largely remained in place until the 1980s. Beginning in the mid-1990s, the scholarly literature dealing with federal Indian law bemoans what Robert A. Williams calls the death of federal Indian law. In a 1996 landmark publication, frequently cited by scholars of federal Indian law until the present day, David H. Getches complains that the United States Supreme Court, which had, quote, generally served as the conscience of federal Indian law, protecting tribal powers and rights, at least against state action, has recently begun to depart from this traditional standard, abandoning entrenched principles of Indian law in favor of an approach that bends tribal sovereignty to fit the court's perception of non-Indian interests, end of quote. Getches analyzes in detail a great number of Supreme Court decisions from the 1980s onwards. In response to a rapid growth in tribal land ownership and tribal populations, and to tribal efforts to assert powers of self-government, the Supreme Court began to weigh non-native interests and to redesign the sovereignty of native tribes. All these decisions are characterized by what Gedges calls a, quote, subjectivist trend, a marking out of the boundaries of Indian self-government based on the judge's own notions of what is desirable rather than on established rules. Whenever a decision involves non-Indian interests, Gedges claims, the judges roll back native sovereignty to avoid cultural conflict. Foundation principles are only cited and acted upon if non-Indian interests are not concerned. Through this judicial subjectivism, Gedges complains, state rights arguments, pruned so vigorously by Marshall in the Trilogy, have regained power. This state of affairs has continued well into the 21st century. In 2006, the later UN Special Rapporteur of the Rights of Indigenous Peoples, James Anaya, complains about the, quote, limitations of the United States legal order. And he goes on, within the architecture of the domestic legal order, doctrines derived from colonial era practice continue to rear their heads and impede the reversal of the status quo left by the colonizing process, end of quote. And in 2010, native legal scholar Walter Echota concludes that domestic law is, quote, ill-suited for the task of protecting native cultural integrity as it is weak, if not non-existent, end of quote. Robert Conley's novel Mountain Wind Song needs to be read as a literary negotiation of the judicial subjectivism of the United States Supreme Court and a scholarly swan song on the death of federal Indian law and its inability to protect native rights. The novel's frame narrative is set in contemporary Georgia, where a Cherokee grandfather tells his grandson the story about Okonichi who falls in love with Waguli shortly before the Indian removal. Removal separates the lovers. Waguli is forced to move west to Oklahoma by foot and steamboat, while Okonichi initially hides with other Cherokees in the east, then starts searching for Waguli, searches him for 4 years, and in the end, of course, the couple is reunited, but the couple is reunited in the east and starts living on a piece of land in the east with the help of Anglo-American settlers. So this is the plot. As you can see, this plot suggests that Mountain Wind Song is a rather conventional novel, a standard coming-of-age narrative which serves as a frame for historical romance with in part very stereotyped Native American characters. So we have the Native American princess, we have alcohol, whiskey consumption, so we have all the staples that characterize sometimes very stereotypical literature. So why am I dealing with this novel? Well, I argue if read in light of the legal developments around the time of its publication, however, Mountain Wind Song turns out to be a politically highly relevant text. Underneath its conventional plot, the novel engages with the shortcomings of federal Indian law and its inextricable complicity with the project of colonial conquest and subjugation. As portrayed in the novel, federal Indian law serves to justify the imperial project of conquest and native dispossession and to clad it in the language of law. Federal Indian law is metonymically embodied in the text through the Treaty of New Echota. And I just want to briefly mention the context. The Treaty of New Echota was actually signed in December 1835 between the US government and a minority faction of Cherokees. And it was an illegal treaty because the minority faction was not authorized by the Cherokee government to do so. And in this treaty, actually, this minority faction negotiated removal, the details of removal, the terms of removal with the United States government. So this is why the Treaty of New Echota is very important in Native American historiography. Chadwick Allen has shed light on how indigenous activists and writers, rather than deconstructing and questioning the authority of treaties, have re-recognized and reified the discourse of treaty for their own political gain. Allen argues, indigenous minority redeployments of treaty discourse insist that dominant power remembers the cross-cultural and cross-national agreements it forged with indigenous nations during previous eras. Such redeployments work, therefore, to re-center the discourse of treaties, to re-establish treaty documents as powerful and authoritative, and as binding on the contemporary settler nation, end of quote. Treaties, as numerous scholars have illustrated, embody an agreement of the essential, albeit supervised, sovereignty of Indian nations, and of substantial separatism as well as federal protection from the infringement of native rights by states. They also signify Native Americans' ongoing distinctiveness as nations and peoples. One of Allen's examples of this native redeployment of treaty discourse is Conley's Mountain Wind Song. Like many other native writers, Conley, Allen claims, re-recognizes a treaty discourse acknowledging Indian sovereignty and insists on the continuing authority of these documents. In contrast to Allen, I would argue that Conley questions rather than re-centers the authority of treaties, highlights their highly fraudulent nature, and deprives the reader of any hope for restorative justice for Native Americans from within the US American domestic legal system. Mountain Wind Song is particularly remarkable in that it includes the entire text of the Treaty of New Echota. Stretching over 18 pages, the Treaty of New Echota is the text around which the novel gravitates. Due to its sheer length and its highly complicated bureaucratic register, it sits very uncomfortably within the easily readable love story between Okonichi and Waguli. So here I just brought you a scan from the book. So you're reading the novel. Well, this is another excerpt I'll talk about in a second. And all of a sudden, the treaty language starts. And without announcement, without an indication of sources. Rather than presenting it as a document of Cherokee sovereignty, Conley, through his placement of the text, suggests that it was not a lawful agreement and blatantly contradicted Cherokee structures of political decision-making. Preceding the treaty, when I learned I have two here, preceding the treaty is Charles C. Royce's 1887 historical account of its prehistory. The excerpts from Royce suggest that removal went into effect for two reasons. First and foremost, due to the machinations of one American individual, President Andrew Jackson. Secondly, through the actions of the members of what would become known as the Cherokee Treaty Party, who, in order, quote, to enhance their own importance, acted against the majority Cherokee opinion and signed the Treaty of New Echota. Read against Royce's text, the Treaty of New Echota appears as a thoroughly corrupt, treacherous, and fraudulent colonial document. Its own narration of its prehistory cunningly distorts the fact that the treaty was concluded with a group not authorized to do so. This distortion is achieved through minute factual changes, through a lack of clarity, or through outright lies. This is the end of the treaty. Actually, here we get all the signatures, everybody who signed the treaty, just as it looked in the original document. The signatures of the members of the so-called Treaty Party at the end of the document visualize their complicity. Their actions flatly contradict the democratic decision-making processes among the Cherokees that Conley greatly highlights throughout the novel. So throughout the novel, we are time and again being told how every individual opinion counts, on how the Cherokees used to have a decentralized government before a formal central government was adopted as a response to Anglo-American demands. So this is what the novel emphasizes throughout. His juxtaposition of such processes in which every tribal member is invited to participate, and the way in which the Treaty of New Echota was concluded, points our attention to the dishonest and manipulative nature of colonial policy and its written manifestations rather than to the native sovereignty inherent in treaty making. More often than not, treaties, Mountain Windsong suggests, are the opposite of sovereignty, as they are concluded with individuals not authorized by their tribes. Perusing the pages following the Treaty of New Echota, the reader of Mountain Windsong realizes that the treaty was a document the United States did not consider binding, at least not with respect to the articles that included promises to the natives. The further Vaguli is forced westward, the more deceptive the treaty's provisions prove to be. Just to give one example, Article 8 states that the Cherokees are to be, quote, comfortably removed, with the government providing a sufficient number of steamboats, baggage wagons, quote, so as not to endanger the Cherokees' health, and that a physician well supplied with medicines shall accompany each detachment of emigrants removed by the government, end of quote. On his trail west, Vaguli repeatedly points out the lacking number of wagons and horses, so that even many of the sick, old, and very young have to walk. Moreover, he sees people dying in masses without medical help, very often from the low quality of food provided by the government. Conley has Ralph Waldo Emerson, one of America's literary geniuses, function as his mouthpiece when passing judgment on the Treaty of New Echota. In his letter to President Martin Van Buren, also inserted in the novel, about a dozen pages after the treaty, Emerson calls the treaty a, quote, sham treaty, a needless act of terror, and an instrument of perfidy. He views it as the result of an unjust colonial machinery and as a conspiracy that is self-perpetuating and that cannot be stopped by the protest of civilians. Aside from emphasizing the hollowness of treaties, Mountain Windsong presents the rulings of the United States Supreme Court concerning Native Americans as similarly non-binding to the American government. In a dialogue between Okonichi's father and Vaguli, the former explains to the latter that even the Supreme Court decisions such as Worcester versus Georgia were not binding to the president, whereupon Vaguli responds in disbelief, quote, the great chief of the white men ignores his own law? To which the father replies, yes, are you surprised? In such a climate, there is no hope for the Cherokees, and no chance to reach a just agreement. When Vaguli asks Okonichi's father, will we have to move? What will become of us? The latter can only reply, I don't know. Thus, the novel's bleak message is that the entire American political system is so infested with colonialism and the ideology of conquest that individual interventions do not succeed at achieving justice, that Native Americans can only advance so far under an unjust legal regime, and that any gains remain subject to divestment at the discretion of government. So I'll come to my next part, human rights as an alternative jurisdictional framework of Native resistance. Parallel to the critical debates in legal scholarship and Native literature about the limitations of the United States domestic legal order, Indigenous politics internationalized, and Indigenous people began to seize upon the institutional and normative regime of human rights that was brought within the fold of international law in the aftermath of World War II and the adoption of the UN Charter. In the 1970s, Indigenous people for the first time took part in a series of international conferences and directly appealed to international intergovernmental bodies. The 1977 International Non-Governmental Organization Conference on Discrimination in Geneva promoted a transnational indigenous identity and patterns of global coordination. And this is what Ronald Neeson has called indigenism, actually. Despite their initial skepticism of the usefulness of international rights for their cause, from the late 1980s onward, Indigenous rights advocates began to increasingly ground their demands in a generally applicable human rights principles. In 1993, indigenous peoples' heightened international activism convinced the UN General Assembly to declare 1993 the International Year of the World's Indigenous People, followed by an international decade carrying the same theme. Indigenous peoples' increasing deployment of the moral and ethical discourse characterizing the human rights movement is also reflected in Native American writings on the Indian removal. Time allows me to address only briefly how Conley's Mountain Wind Song introduces the normative framework of human rights as an alternative to the existing domestic legal order the novel has portrayed as so ill-suited to advance Native claims. The novel's climax in terms of cruelty and violence is Waguli's internment in the stockade. By use of internal focalization, that is, through Waguli's eyes, Conley has the reader perceive the atmosphere in the stockades, quote, sights and sounds and smells. The abounding parallel constructions, beginning with he saw or he heard, enumerate the assault of the stockade on the Cherokees' lives and health, and minutely outline the degrading treatment they suffer at the hands of the colonizers. Women are raped, prisoners are made compliant through whiskey, and children die from malnutrition. The crying of children, the wailing of mothers, and the grounding of the elderly are contrasted by, quote, the laughter and the cursing of soldiers, end of quote. Much more than sight or sound, however, the smells in the stockade embody what Waguli considers white man's hell. And here I quote, fetid odors of human waste, the stench of sickness, the scent of death, the rank smell of rotten meat, the general rankness of unwashed bodies crowded together in too close proximity, all combine to produce a suffocating, mephitic assault on nostrils and lungs, and a savage and virulent affront to the dignity of humankind, end of quote. Central in this passage and paragraph, hence its climactic position at the very end, is the phrase dignity of humankind. One could argue that Conley's use of the phrase is a vernacular one, implying merely that every human being possesses an intrinsic worth that should be commonly respected. However, in a text so saturated with the law and its multiple manifestations, it seems not far-fetched to connect this mention of human dignity with the concept's rich legal history. Human dignity, as Christopher McRudden has recently demonstrated, is deeply rooted in the history of ideas, with its origin reaching back as far as Roman philosophy, winding its way through the political philosophies of the following century. In the first part of the 20th century, it began to enter legal and particularly constitutional and international legal discourse in any particular sustained way. McRudden first and foremost emphasizes the inextricable connection between human dignity and human rights. Human dignity, he argues, is, quote, one of the key concepts which underpins and informs the human rights enterprise, end of quote. Niels Patterson even considers human dignity the, quote, founding function of international human rights law. A quick glance at the Universal Declaration of Human Rights and its frequent use of dignity in the preamble and in various articles reveals that by 1948, the notion of dignity had become a central organizing principle in the area of universal human rights. By having Baguli conceptualize the colonizers' crimes as an assault on the human dignity and thus on human rights, Conley introduces in the novel an alternative to the legal framework of federal Indian law, possibly with greater potential for restoring justice than indigenous protests or maneuvers from within the domestic legal system. By emphasizing human dignity, Conley points our attention to the different ontologies of the regime of human rights and federal Indian law. While the former is rooted in the philosophical concept of human dignity and has the welfare of human rights as its subject, and is thus neither concerned with nor dependent on the interest and will of settler states, the latter originates in the settler state itself and is hence inextricably tied to its political interests and will. While on the level of story, Mountain Windsong does not offer any answers as to how the human rights approach might be used by Native Americans, its own employment of human rights rhetoric to critique settler colonial practices alludes to the potentialities inherent in this alternative legal discourse. The human rights paradigm might prove a reformative inroad into the morally tainted, self-justificatory and self-serving domestic legal regime. And now I'll come to my third part. Kernels on a Cob of Corn, International Debates about Human Rights, and Diane Clancy's Pushing the Bear. Now I'm getting into Erica's terrain. International debates about indigenous human rights became particularly fervent during the 1990s, when the UN Working Group on Indigenous Populations worked on a draft declaration on the rights of the indigenous peoples that was eventually to be adopted by the UN General Assembly and that was to achieve the status of a human rights declaration for indigenous peoples. And actually, the General Assembly adopted this declaration in 2007. It took a very long time, a couple of decades actually, and the only nations who were opposed and did not sign were the settler nations Australia, Canada, New Zealand, and the United States. And they reversed their decision in 2010, but it took them 3 years to reverse that decision. The adoption of the declaration was hampered by a number of conceptual debates. At the forefront of these debates was the question of how indigenous rights, that is, a body of collective rights, could be embedded in a human rights regime that, according to Siegfried Wiesner, was staunchly individualistic and inhospitable to claims of collectives. The debate about the recognition of collectivities and collective rights fundamentally changed the core normative assumption of post-Second World War international law, that a regime of individual human rights is sufficient for achieving an acceptable international order. When it came to legally codifying such collective rights in the form of an indigenous rights declaration, representatives from the various states, first and foremost the United States, voiced their skepticism, if not outright opposition. In the report of the Working Group on Indigenous Populations from August 1993, the representative from the United States expressed her concern about the extent of collective rights that the proposed declaration assigned to indigenous groups. She was afraid that such group rights could lead to the submergence of the rights of individuals. When 2 years later, the UN collected comments from governments about the draft declaration recently adopted by the subcommission, it was again the United States which contended that the text refers to, quote, rights which do not currently exist under international law, end of quote. The United States reasoned that based on, quote, its domestic experience, it held the general view that the rights of all people are best assured when the rights of each person are effectively protected, end of quote. Diane Clancy's novel, Pushing the Bear, needs to be read in light of the debates about the relationship between individual and collective rights in the context of the draft declaration. Pushing the Bear, I claim, complements and enhances these debates in various ways. On the one hand, through its narrative technique and its emphasis on the historical presence of individual rights within the Cherokee Nation, it corrects the colonizers' century-old story according to which native tribes, through their emphasis on collectivism, largely ignored the interests of individual members. By suggesting that in native societies, individualism as well as individual rights exist and are respected, the novel questions the oft-repeated claim that indigenous collectivism cancels out individualism or hampers the development of individuals. On the other hand, by advocating the complementarity, interdependence, and harmonious balance of individual and collective rights, Pushing the Bear contributes fruitfully to scholarly discussions about the relation between individual and collective rights in international law, and to scholarly attempts to bridge the theoretical gap between corporatist and liberal individualist scholarly approaches to interests. And here is a scan from the novel. So when I talk about the narrative, Clancy's narrative technique, you can actually see how it is realized on the page. Most conspicuously, it is through her choice of narrative technique in Pushing the Bear that Clancy highlights the ongoing presence of individualism in Cherokee culture. She relates the Cherokee Nation's traumatic experience of walking the Trail of Tears by including the voices of 41 narrators, the majority of whom are Cherokees. There is no hierarchy of voices. Each voice is separately identifiable, telling her experiences and her own version of events. Out of these individual voices emerges the communal story of Cherokee removal. The individual narrators tell their stories as members of a collective, more precisely a nation. While non-indigenous American historical novels tend to individualize the experience of collectives, Pushing the Bear fashions the Trail of Tears as both a collective and an individual experience. The novel's narrative style, which has been called communal first person, embodies a simultaneous presence of collectivism and individualism in Cherokee tribal culture. The existence of many clearly identifiable voices suggests that the individual, her identity, emotions, and personal desires, is not submerged by her being part of a collective. Nevertheless, the individual narrator's frequent use of the first-person plural personal pronoun we, that is their conceptualization of themselves as members of a group, demonstrates that their existence and well-being is inextricably tied to and dependent on the continuation of the group. So all the time you can see in the novel, even though they're talking from their own perspective, they talk as we, as the group, and they're always thinking about the fate of the group and the continuation of the group. On the level of story, Clancy similarly emphasizes the existence of individualism in the Cherokee Nation by placing individual property rights at the center of her narrative. Kenneth Bobroff has elaborated on what he calls the myth of common ownership that has haunted Anglo-American thinking about Native Americans ever since the 17th century. According to this myth, Native societies are, quote, communist, hold all their lands in common, and do not recognize individual property rights, which confines them to the status of uncivilized savages. This myth, I would argue, still haunted the debates about the draft declaration. Indigenous collective property rights, in particular collective land rights, were among the earliest and most insistent demands of indigenous peoples within the human rights framework. Besides being perceived as threatening to the existence of settler states, indigenous collective property rights were, in historical fashion, viewed by state representatives as incompatible with, if not to the detriment, of individual property rights. Pushing the Bear hones in on the idea that by the time of removal, that is by the late 1830s, individualistic conceptions of ownership hold a firm place in Cherokee culture. Rather than being strangers to the idea of property, Clancy's protagonists are presented as desiring personal possessions and as defining themselves through what they own. The cabin, the icon of Anglo-American colonial expansion, is presented in the novel as the focal point of Native longing for individual possessions. On the trail, Mary Toll is the character who most often mourns the loss of her cabin, as well as the fields surrounding it. When the soldiers allow her to head back and retrieve some possessions, she encounters a family of white settlers that has already occupied her home. And here is a longer passage from the text, but I think this shows very well this possessive desire. I pulled the cooking pot out of the hearth with my hands, and it spilled on the floor. Mine, I screamed at them in Cherokee. My plates and forks. I turned the table over. The children screamed and danced with terror to their mother. The man got his musket. He aimed it at my head, but the shot went past me. I kicked over a chair in my rage. He loaded his musket again, and the soldier rode his horse nearly into the cabin. This cabin is mine. The words spit from my mouth. My body was stiff as a beam. The soldier grabbed me and threw me outside the door. I heard the soldier yell at the people in the cabin. There was a struggle, and he came out with the cooking pot and blankets he ripped from the bed. The musket, I told him, my forks and ladles, the kilts my grandmother made, our corn. It was my farm. We had not even cleared all the fields yet. Who is the white man to drive us from our land? I spit at the soldier's feet. He stuck me with his bayonet. The sharp point against my breastbone quivered my knees. He turned me away from the cabin and marched me up the road. My legs wobbled and I fell to the ground. In this passage, the repeated use of first-person singular possessive adjectives and pronouns emphasizes the presence and significance of concepts of private property within Cherokee culture and their coexistence with systems of communal property, our land in the end. And land was owned communally by Cherokees. The word mine is used in the novel later again, when Mary Toll's brother Tanner muses upon the discovery of America, when the white men, quote, dragged their ships across the ocean, mine, they say, end of quote. The reader links these two italicized possessive pronouns. The colonizer's mine, voiced at the moment of discovery, and the motor of colonial expansion over the next centuries, and Mary Toll's mine, her desire to keep what her tribe had been taught to value by Europeans ever since conquest. Pushing the Bear thus alleges that by the time of removal, the English mine, that is, the Anglo-American concept of private property, had entered the Cherokee language and was a fixture of Cherokee culture and thought. This passage, especially here, the end, my legs wobbled and I fell to the ground, also connects Mary Toll's personally owned belongings to her body and her physical well-being. Upon realizing the loss of her possessions, her body first stiffens and then collapses entirely. During the trail, her physical suffering in the wake of her dispossession becomes even more pronounced. And here is another quote. The cold sat upon my bones. It was as though I had no clothing. It was as though I had no skin. I was nothing but a bare skeleton walking the path. I felt anger at the soldiers. I felt anger at the people in my cabin. They were using my plates and bowls, sleeping under my kilts. I cursed them. There was something dark and terrible in the white man. End of quote. Through her dispossession, Mary Toll's body is stripped of its clothes, even its skin, which suggests the intimate connection between her identity and her possessions. Being reduced to a bare skeleton, she is not recognizable anymore as a Cherokee, not even as a human being. Through Anglo-American acts of theft and unlawful dispossession, Mary Toll feels bare and deprived of her identity and civility. And Mary Toll is actually not the only character in the novel defining herself through what she owns. Another character is her husband, Noboti. He's even presented as more intensely driven by the desire to possess. He confesses to have mainly married Mary Toll and his previous wives because of their possessions. So this is a theme that is sort of going through the entire novel. Not only does Pushing the Bear illustrate the existence of private property among the novel's characters, but it also criticizes its preponderance and spells out its detrimental impact on tribal life and socio-political structures. Most significantly, the relations among tribal members are represented as strained and fractured. The marriage of Mary Toll and Noboti represents such fragmentation on a on a microcosmic level. Before the trail, their marriage functioned because they managed to satisfy each other's proprietary desires. Meritol owned the land, while Nobuti provided her with a cabin and the proceeds from the land. With their possessions being gone, the bond between them has dissolved. Nobuti can only embrace Meritol when he imagines her to be the farm, which suggests that what he has loved was the farm, but not his wife, who to him has been a means to a proprietary end. Pushing the Bear also employs visual registers to unveil how their intense attachment to private property fosters social fragmentation among the Cherokees. And here I brought with me, these are the property lists inserted into the novel, and Clancy indicates that she took these lists from the Cherokee Register of Valuation, and the Cherokee Register of Valuation is housed in the National Archives in Washington, D.C., and it was a register that the Cherokees, or actually agents by the government, assembled in order to note the wealth, the property of individual Cherokees, and the supposed purpose was to reimburse the Cherokees after removal, which of course never happened. So on these lists, I brought them because these lists visualize. Here you have Chief John Ross. He's the leader, obviously he's the chief of the tribe, and he has the longest. This list even goes on the next page. You can see what he owns. It's precisely taken down. And here you have Wasgulta. He or she doesn't own very much. The same goes for Sally B. Hunter, but it's exactly noted down how many things of a kind, how much land, how is the kitchen appliances, so on and so forth. These lists, of course, on the one hand show that there is private property in the Cherokee Nation. On the other hand, they also demonstrate that private property fosters a certain social fragmentation among the Cherokees, because there is a stratification within Cherokee society according to economic wealth. And this in turn produces jealousy and envy. And there are a lot of passages in the book where characters are envious of each other's possessions. Thus, while the novel emphasizes the presence of personal property interests within Cherokee culture, it also warns its readers of their potentially negative impact on the coherence of the Cherokees as a group. Taken to their extreme, they can entail the fragmentation of the tribal collectivity into an agglomerate of individuals. The intense fragmentation during the trail causes Meritol to feel for the first time what it means to be individual. I felt separate, on my own, individual. I'd heard that word. Now I knew what it meant. And here, of course, is inserted a very intense critique of Western individualism. She feels like an isolated entity, separate from her community. Such intense feelings of individualism and separatism from community cause Meritol and other characters to question their emulation of Anglo-American values, including their definition of themselves through their personal possessions. In order to avoid such fragmentation of tribal life, individual interests, Pushing the Bear suggests, need to be complemented by collective interests. The Trail of Tears is portrayed in the novel as a potential site for overcoming rampant individualism and for bringing collectivism and individualism into a meaningful relation. This vision of complementarity is encapsulated in the powerful image of the kernel and the cob of corn that Clancy uses various times throughout the novel. At the height of fragmentation, when Tanner criticizes Nobuti for his proprietary interest in his wife, the latter has a vision of peoplehood while looking at the Cherokees walking the trail. I looked at the long line of walking people behind me like kernels on a cob of corn. For a moment, I could almost believe we were walking a holy walk. As a unit, as a people, one kernel following another, our voices united, If we could be one in our walking, we would make it to the new territory. All of us had a part, and if some were silent, it would be like a cob with kernels missing." End of quote. In Noboty's vision of Cherokee peoplehood, both the individual and the collective are by no means incompatible with each other, but interdependent. Each kernel is important in and by itself, but it is also part of the cob, the people. A cob without kernels is not really a cob, and kernels cannot survive for long without being attached to a cob. That such complementarity of individual and collective interests leads to a healthy social fabric is suggested in the reminiscence of planting by the voices as they walked. Quote, "The people work together. All of us move from field to field until the seed is sown. Everyone works in our individually owned fields. Our goods are shared, distributed among us." End of quote. Clancy's complementary view of individualism and collectivism challenges the opponents of indigenous collective rights, who see the latter as incompatible with the liberal individualist political philosophy that most settler states subscribe to, and that is considered to underlie the Universal Declaration of Human Rights. Through its reflection on the relationship between collectivism and individualism, Pushing the Bear also adds significantly to scholarly attempts at clarifying the relation between collective and individual rights in the 1990s and early 2000s. And I think this is ongoing, but I'm just relating to the literature that was published at the time the novel was written and published. The discussions about indigenous rights in international law have prompted scholars to inquire into whether group rights are in sympathy with and perhaps form part of the morality of human rights, or whether they belong to quite a different and potentially conflicting morality. The model of complementarity and interdependence between individual and collective rights in indigenous societies Clancy proposes in her novel feeds into the argument made by scholars such as Jeff J. Corntassel and Cindy Holder in 2002. And this is just one example of a scholarly position trying to do the same. They criticize the prevalent liberal individualist and corporatist approaches to collective rights for dichotomizing between individual and collective interests, and for describing the significance of group membership for individual well-being in primarily psychological terms. In contrast to this, they argue, quote, "The real-world demands of indigenous groups place a great deal of emphasis on concrete ways in which the preserving of communal life can be important to individuals' well-being. These practical aspects of communal life make individuals' group interests a lot like their individualized ones, and so suggest that such rights, that is, collective rights, do not introduce new or distinctive theoretical questions." End of quote. As an indigenous text, Pushing the Bear offers a more sophisticated understanding of the relation between individuals and groups than both liberal individualist and corporatist approaches. The novel emphasizes, on the level of both story and discourse, the significance of indigenous communal life, not only for the psychological, but also for the material welfare of the individual group members. If individual interests are embedded in collective pursuits, individual and collective rights are mutually interactive rather than in competition. Through its emphasis on the complementarity and interdependence of individual and collective rights, Clancy's novel invalidates the widely held non-indigenous view that individual indigenous rights inevitably suffer in the presence of indigenous group rights. I'll come to my conclusion. My readings of Conley's Mountain Wind Song and Clancy's Pushing the Bear, in light of domestic and international legal developments, demonstrate that Native American removal literature is particularly apt to provide an arena through which Native writers are able to represent, complement, and enhance the legal and political discussions in the context of UNDRIP, that is the United Nations Declaration for the Rights of the Indigenous Peoples. Restrained only by the laws of fiction, they can employ the traumatic events of removal and their interpenetration by the law in order to challenge the terms of the debate and to develop alternative perspectives. Besides sounding out the limits and potentialities of various Anglo-American legal frameworks, Conley's and Clancy's writings also inspire discussions within Native America about the forms and shapes of indigenous peoplehood. I would like to close this talk by citing Native literary scholar Greg Womack, who emphasized the significance of Native literature for envisioning indigenous peoplehood. A key component of nationhood is a people's idea of themselves, their imaginings of who they are. The ongoing expression of a tribal voice through imagination, language, and literature contributes to keeping sovereignty alive in the citizens of a nation, and gives sovereignty a meaning that is defined within the tribe rather than by external sources. End of quote. Thank you.